Uh, So, good afternoon, Dr. Dinesh. Please start.
Sir. Very warm welcome on the behalf of IB Delhi, and very good afternoon to all of you. And thank you so much for sparing time for this very important webinar. And today we are celebrating Medical Legal Protection Day, which are actually on 17th February. But there are a number of activities all across India under the leadership of our beloved President Dr. Neelam Mohan ma'am and the chairperson Dr. Satish Sharma sir of the chapter, and Secretary Dr. Hemant Gangolia, and Treasurer Dr. Astos Mahapatra. And it is one of the, I think, one of the most active chapter in the recent times. And it's all credit goes to the office bearers of Medical Legal chapter. And we hope Dr. Neelam is also joining very soon.
She has
And
joined. She has joined.
yes, yes,
She has
yes, ma'am.
joined.
Welcome, ma'am. Welcome, ma'am. Welcome,
Welcome,
ma'am.
madam.
And ma'am
Thank
is a
you.
chief guest for today. And ma'am is a one of the, I think, legendary president of the IAP, and she is the most hardworking, most sincere, and from my heart, I can say. And ma'am is so particular in each and everything. And ma'am, it's inspiring from you for all of us. And we are honored to have you on this session on Medical Legal Protection Day. And I would like to invite you for your comments, ma'am, please.
Thank you so much, Dinesh. And at the outset, I would really like to thank Dinesh and IAP Delhi for this stupendous. I was just messaging to Dinesh, and so quickly, I was just telling him that it is, as the president of IAP, it is a responsibility which, as for the constitution, we need to follow. And the constitution says that you should be responsible for all the activities of IAP. And it should be my proud privilege when the chapters, when the state team, they do. Because IAP has grown so significantly that doing activities only under central IAP may be difficult, but at the same time, we need to learn and respect from all the chapters that when they do an activity at the center, we need to support. And similarly, each chapter, each state, whatever they are doing, it is the responsibility of the president to ensure that they are highly appreciated for the efforts that is being done, because that is how we can march together. So when I talk about it, not that I am very biased, but maybe because I was brought up, uh, or rather groomed up as an efficient doctor in Delhi. So that connection is there when it comes to academics. And I've been looking at the entire country, and I realize there are so many strengths of each state which mesmerizes me when you look at Maharashtra, when you look at Kerala, everybody has something to teach you. And what has Delhi taught? Delhi has can boldly and they can claim that one of the highest number of institutes in a given geographical area, they can proudly claim that, which is the truth, because majority of the big national institutes of reputation within a small geographical area are there. So that is something which Delhi proudly talks about their academics. And we are all realizing that we have always focused so far in our health towards reducing mortality and talking all about topics which was focused on infections, vaccines, antibiotics, pneumonias, diarrhea, developing systems, neurology, gastroenterology, and pulmonology, respiratory. But now suddenly you are in a place, in a crossroad where you realize that there are so many different things which are emerging, whether it's whether it's NCDs, whether it's allergies, whether it's environment, and everybody who are developing these chapters, they have so much to do, and in that we realize the significant importance of medico-legal chapter, because this chapter belongs to everyone. Whatever specialty you are, you need to understand how you need to work with ethics, evidence, and law. So, irrespective of your chapter, this is a important point, and therefore, it was my proud privilege that I could be instrumental in getting a TOT for the able leadership this year of Dr. Satish Sharma, Dr. Hemant, and Dr. Uh, our treasurer from East,
Dr.
Dr.
Mahapatra.
Ashutosh ji, Mahapatra Ashutosh. So they have been very dynamic. I mean, God planted them there to ensure that, with the experience that they've had of performing in the past. And I could have thought myself to be lucky that I could be available during the presence of this team so that. And it is nice that each state we should be able to approach. And since we've done a module, and I would also like to promise that I'm going to do this module digitally eventually, which is going to be probably in the month of October. But till then, we should try to do it with all the states, the zones, and all meetings so that once we complete it, then we can take the module digitally. Is that okay, Dr. Satish and Hemant?
Thank you, madam.
Till
Thank
then,
you. Thanks,
till
madam.
then, yeah, till then you go with the module in the states and in the zones meeting. And subsequently, we should do it digitally as the finale. So that finale is going to be done so that everybody is benefited, and I support in that. And today, I want to thank the leadership. Ajay Kumar Gupta, he is like an extremely academic person, and under his able leadership as the president, IAP could see this. And I can see that they have been taking Dr. Neeraj, who's now marching into the IAP administration and has taken over as the vice president, and Dr. Mukesh Verma, who is the president elect. जो होता है उसके पीछे कुछ छुपा है. So with the president elect, that's very. And then Dinesh Goyal, who is now one of the most dynamic persons I knew because I saw him working in the West Delhi, Dwarka. And though we did not know much of each other earlier, but we just clicked in the way we were thinking about and planning. And so, Dinesh, I must compliment you for your wisdom, and being in this field, you could get it. So, heartiest congratulations to all of you.
Thank you, ma'am. I think network, मैम का नेटवर्क इशू हो गया शायद. मैम आपका नेटवर्क चला गया शायद. Am I audible to everyone?
Yes,
Yes, you are audible.
So,
I
Dr.
think we
Dinesh,
should-
please continue. In the meantime, Madam may rejoin.
I think we should wait for 5 seconds. Yes.
We can wait for 15 seconds. Let us.
Yes, yes, yes.
Maybe she will rejoin, Dr. Dinesh.
Okay,
Uh,
okay, fine.
Please continue.
So before starting the session, I just want
She is
ma'am ने
there.
शायद दोबारा
She's
join
back.
किया.
I would just
Yes,
end
yes,
up
yes.
by just saying that I've lived to my commitment and I've got an appointment with the commissioner and that. So the poster we did, I will get it given to him, Dinesh, as promised to you. So
Yes,
we've
ma'am.
got a commitment.
Yes,
We
ma'am.
shall give it that so that we can share that poster then to the country. I am
Yes.
sending one anemia poster already.
Smart
So
poster.
in that courier, I can put this courier. So within the same cost, I shall send it across.
Great, ma'am. Great. Wonderful.
Okay. Thank you so much.
Thank you, ma'am.
Thank you, ma'am. Thank you so much,
madam,
ma'am.
for
Thank
your encouraging remarks for all of us. And since the day you have joined, you are looking after the rights and the welfare of all the pediatrician all over the country. and we appreciate your vision. And now we'll put into motion the mission mode, madam, for you.
Thank you.
Yeah, yeah.
Thank you, ma'am.
Thank you, ma'am.
Thank you.
Thank you so
Thank you.
much.
Now I just want a word from Dr. Satish Sharma, sir, as a formality, if
Yes,
you
sir.
want, sir.
Sir,
Yes.
actually, the purpose of this, we are, as all of you know, we are celebrating this Medical Protection Day for Doctor 17 Febs. And we have seen recent year there have been unsettling rise in the prosecution against doctors. And they are initiated either through the private complaints or through the police officer. Even the police officer, they are not knowing the laws and that why they are doing it. And such legal proceedings, they are not only put our pediatrician under stress, but also risk their profession and their career, and regardless of the case outcome. Case turned out to be true, this may be false. So in this Honorable Supreme Court of India has put at these issues, and in Martin D'Souza versus Mohammed Asfaq, this judgment was given on 7th Feb. Then similar, there Jacob Matthews case in the government of Punjab, Kusum Sharma, Batra Hospital, and Suresh. All these are favoring these doctors. And the Supreme Court put these guidelines that private complaint may not be entertained without prima facie evidence. So such as an opinion of the expert should be taken before lodging FIR against the doctor. And investigating officer must obtain independent opinion, either from the district board or from the doctor in the government hospital on the same specialty. And the doctor accused of negligence should not be routinely arrested, and police officials should refrain from harassing them. And the complaint against the doctor and the hospital, they should be referred to a competent doctor. So it is the duty of the civil society, our social person, that the medical professionals, they are not unnecessarily harassed or humiliated, allowing them to perform their duties without any fear. So these are the judgment. The secondly important thing is the increasing violence against the doctors. And we should know our rights, So there are certain states, they have put this right, State Medical Protection Act. Right now there are 26 states, including union territories, and Delhi is also one of them. So against this, the doctor can't be arrested same way. And so this was the purpose, that the both things, this court judgment, Supreme Court, and the State Protection Act, they should be told to our DGP, IGP, or whatever SHO, so that they can percolate these messages to them.
Thank you, sir.
Should not be harassed. So this is the main protection about these doctors are there. So I will now over to Dr. Dinesh.
Yeah, thank you, sir. Thank you so much. A line, sir, from Dr. Hemant, sir, Secretary, Medical Legal Chapter.
Thank you very much, Dr. Dinesh, sir. All respected dignitaries on this dais. Actually, way back 2009, 17th Feb, this landmark judgment of Martin D'Souza case came. The crux of the case is not to arrest doctors, but refer to the committee of doctors, as already said by Dr. Satish Sharma, sir. And 4 important judgments along with that, the Kusum Sharma versus Batra case law, as well as Suresh Gupta, and the Jacob Matthew case. The important Kusum Sharma versus Batra, the 11 principles which are laid down are there. The point of this celebration is, it all looks nice on the papers, everything is there, but the local peripheral police stations most of the time are not aware of that. So our job as a medical fraternity is that to make them aware of these things are existing. And therefore, every district branch or city branch must have received the mail from the CIP mentioning the memorandum which has to be submitted to the local police station, have a courtesy meeting with the police station, make them aware and give that memorandum to them. As well as there are some press release which is in English and Hindi to publish in the newspaper. All of you can organize small press conference highlighting these things and then going ahead. And one more thing, there's just as Dr. Satish Sharma sir has said, this State Medicare Protection Act is there, which is prevention of damage and violence. But most of the police stations are not aware of this also. The importance of that, this, whenever we file FIR, if any mishap occurs or the charge sheet filed, it is to be under this act. because it's in this act, it is a non-bailable, cognizable offense. So that is the important. So our job as a medical practitioner is to make to aware to all the police station and make our doctors also aware. Most of the doctors are not aware. So our job is to do that. And that is the importance of the 17th February. And in that view, we are organizing on this 20th by IIP Delhi branch. So heartiest congratulations to IIP Delhi branch to organize this wonderful webinar. I'm sure with all the speakers around, it will be a great session and learning for everybody. Wish each one and everybody happy learning. Thank you, Dr. Dinesh sir, for inviting me, as well as Dr. Ajay Kumar sir as the president of the IIP Delhi. Thank you.
Thank you, sir. Thank you, sir. A word of welcome from Dr. Ajay, sir, President IIP Delhi.
Thank you, Dr. Dinesh. On behalf of IIP Delhi, I welcome Dr. Satish Sharma sir, Chairperson, Medicolegal Chapter, Dr. Hemant Gangolia, Secretary, Medicolegal Chapter, Dr. Deepak Gautam, Treasurer, Adolescent Health Academy. He is also a medical legal expert, and Dr. Deepak Singla, faculty for the today. And as office bearers of a association, we have a duty towards our members to protect them. Because one of the duties of the associations and the purposes of having an association is updating the knowledge of all the members and also protect them as a group. So we must make aware all our members about our rights also, because as doctors we are expected to have duties towards the patients, but also we have certain rights which cannot be sidestepped. And sometimes we are not aware of these rights and these people try to bulldoze us. So we must not get afraid, because a case happened in Rajasthan where one lady doctor committed suicide because she was accused of negligence. Just on the basis of accusal, the police tried to arrest her and she committed suicide. So we must not get into all this, and we must be aware of our rights, and only knowledge can give us this awareness. So I'm really thankful to the Medical Legal Chapter for associating with us in organizing this webinar, so that we can spread this information to all our members. Thank you very much.
Thank you, sir. Thank you so much.
Dr. Dinesh sir, only just one line. I've heard Dr. Deepak Gautam is a very practical person speaking on the laws, as well as Dr. Deepak Singla to release some fantastic book. I think so. All four people around, and most you are at Delhi. So you are the, I think so, the bridge between us and the Delhi government. So please look into that. We could get
Yes,
thank you.
Thank you. Thank you. Now, for first talk, I would like to invite Dr. Deepak Singla sir and over to Dr. Deepak Gautam sir to introduce Dr. Deepak Singla sir. And our first talk is from Dr. Deepak Singla sir. Over to you, sir.
Okay, thank you, Dr. Dinesh, and good afternoon, everybody. And like everybody, I congratulate IIP Delhi and Medical Legal Chapter for organizing this much needed webinar. And Dr. Deepak Singla needs no introduction. Sir is a very eminent personality in this circle, in pediatric circle, and everywhere. Dr. Deepak Singla is a medical director of Maharaja Agrasen Hospital. Sir has also written down a book on the medical legal issues. So I request Dr. Deepak Singla to give our deliberations on consent. Sir is giving on documentation.
Yes, documentation.
What important points we as a practitioners misses on the documentations. And really, it's always a pleasure to listen, Dr. Deepak Singla. Sir, please, Dr. Deepak Singla.
Thank you, Dr. Deepak, for the kind words. And I thank IIP Delhi for giving me the opportunity and all the leadership who are there. I will try to share some of the thoughts. Just wanted to confirm, is my slide visible?
Yes, sir. Yes, sir. Visible.
Yes, sir. Yes, sir.
Okay, thank you. Thank you. So basically,
make it full screen, sir. Make it full screen. Make it full screen.
Full screen नहीं हुआ?
नहीं, full screen नहीं हुआ sir.
Full screen है, full screen है.
Next. Full screen नहीं दिख रहा.
नहीं दिख रहा, अभी full screen नहीं है?
नहीं.
सर नीचे से एक बार कर दो आप ये.
देखो मैं करें.
स्लाइड मोड पे कर दो, नीचे स्लाइड शेयर वाले पे कर दो.
ये वाले मोड पे करना है. इस पे किया सुना. Now, is it visible now?
Yes, sir.
अब हो गया?
Yes, done.
Yeah, done. Yes, sir.
मेरी तरफ से पहले भी यही था वैसे.
हाँ, यही था पहले भी.
Thank you. Okay, next 15-20 minutes, I will try to spend why, in spite of the best possible brains, when we go into a medical school and all of us work so hard, but why have we reached this stage where the patient-doctor trust has really gone down? Of course, partly, majority of the factors we can blame on the other side of the table, patients, politicians, and everything. But I think a lot of blame comes back to us. It is like when we point a finger, few fingers will always point back to you. And one of the main reasons is we read everything about the most uncommon syndromes which we have never seen in our life for 30 years. But we don't read simple things like MCI code of conduct, 3-4 pages, nothing else. And most of us don't even, we do everything good for the patient. But when it comes to documentation, we leave it to the junior most person who is also not very much interested. And then we simply go to our common room, sit there, chat, watch cricket, see Sensex, and go for the day. And when something goes wrong, next day we start doing something here and there. Though that creates a bigger problem when we have a temptation for doing overwriting, underwriting. So in the next 15-20 minutes, we'll try to discuss why documentation is so important to protect us. Because as Dr. Satish also said, everybody says judiciary is there to actually help us, provided we give them a scope to help us. Normally, if there is no documentation, there is no defense. Most of the judgments from the Supreme Court have come completely in favor of doctors. They say that doctors work under tremendous stress, so we should support them. And we are thankful to actually judiciary for creating this platform, that right to health, where fundamental right has been made. When India became independent, right to health was mentioned nowhere actually. It was left as a very, very small thing. Gradually, with the Supreme Court intervention and because of some senior judges, it was brought as a fundamental right through purposive interpretation. But health being a state subject, again, there are many, many rules which differ from state to state. So now we come to the conclusion. First thing is, why shall we document? Why it is so important, documentation? First of all, we all know management of patient care. We have to do a handover. We can't be there 24/7. It is a team approach. There are nurses, doctors, physiotherapists. So they can't be talking to each other every time. So documentation makes the bridge between all of them. Second thing is, it is a statutory requirement that we have to document. As we are part of a guild of the Medical Council of India, now NMC, it is expected from us to follow whatever the Act tells us. It is also ethical requirement, legal requirements, and we'll discuss the difference between statutory and legal requirements, and then collection of patient-related data. And we want to do some research and we want to do presentations and all. So again, we need to have a documentation, and we'll cover one by one. Why we want to document for the management of patient care? One is, it is required for the concurrent treatment, continuity of care. We have to do initial assessments, reassessments, everything. And actually the documentation will give a concept to everyone. Even if you're not there, anybody can see that what was to be intention of the doctor. So it acts as a communication between doctors and other healthcare professionals. And whenever we need for research purpose to improve our knowledge, we have to go back to the documents. Statutory requirement is anything which is done through the part of Parliamentary Act, as part of the Indian Medical Council Act. It is our responsibility to correctly document and preserve this document. This is a legal foundation. We have to do it. Because some people who have not gone into the details, there may be a little confusion. The statutory requirements are expressively written in a statute, that is act or legislation. Legal requirements are broader terms. It may be out of statutes, whereas it can also be through common law principles, contract laws, professional codes. So all statutory requirements are legal requirements, but no all legal requirements are statutory. But we need to preserve the documents because of both. And legal requirements, again, medical records are required as per the Indian Evidence Act, which has become Bharatiya Sakshi Act now. Usually summoned in the court of law in following cases: criminal cases for proving the nature, timing, and gravity of injuries; road traffic accidents for deciding the compensation; labor courts; insurance claims; and medical negligence cases that we keep discussing. That in criminal courts, ultimately the charges against doctors is decided based on what we document. Ethical requirements, again, Code of Medical Ethics. Even under National Medical Council, we are still retaining the same part of the Indian Medical Council, that every physician is to maintain medical records pertaining to indoor patients for a period of 3 years. Actually, for the retention of medical records, this is what NMC or MCI says. Rest everything is according to the states also, of course, other than the MLC part. And even from the NHRC, the Charter of Patients' Rights, second right is right to records and reports. Actually, this is the right which we tend to forget. As Dr. Ajay was saying, that doctors have rights. Definitely we have rights. But then every right has a responsibility attached to it. So if it is my right to be respected, it is my responsibility to give respect to others also, to communicate well, to document well, and to listen to the patient's voice when they are asking for records. Sometimes we delay it and then courts take it in a very, very negative way. So we should be all very, very clear about whatever is the mandate from Indian Medical Council, professional conduct, etiquettes and ethics. Especially in this era of AI, as we are entering into this new era, we have to be very, very clear what all data goes out of our hospital through WhatsApp and all, because ultimately we may become responsible to the communication breach. I will just like to tell one thing here. Lot of big chain hospitals have stopped taking Aadhaar as a part of your identity during when you enter the hotel. Like ITC Moria, I know. I went to Bombay, so they refused to take my Aadhaar. This is around 6 months back. They said, give us any document other than Aadhaar. Whereas in most of the hospital, we still take Aadhaar left and right without realizing the consequence of keeping these Aadhaars. And in case we lose that Aadhaar leak, then ultimately when DPDP Act comes, we become a data fiduciary and we are going to have a very big price to pay for that. So we should all be thinking of lines, how to get aligned with the requirements of DPDP Act as well as AI intervention. So medical records constitute a very important aspect of the management of patient. In India, still both the techniques are there. Traditional method is by paper, manual, and we are gradually shifting into EMR, but very few hospitals still have, but both have their own advantages and disadvantages. Now, what is a medical record as per ISO 9001? It is evidence about a past event. What has happened? A record is generated in the do phase of PDCA cycle. Records consist of any data we collect during the operation of the hospital. And records are facts and they should never be changed. I think one thing which I will like people to remember, whenever there is a chaos of any patient, there is always a temptation by physicians to take the file out and do some changes, thinking that ye zyada acha lagega, ye thoda sign bach gaya tha mera. And there starts the problem. There are innumerate number of medical negligence cases where doctors were given a free cheat in negligence case, but they got hold of in the tampering of the records. Court comes very, very heavily when they see that there has been a tampering of the medical records. So we should always retain, protect from alteration. It is a legally sensitive document. And during audits, we should ensure that record integrity is there, access control, retention periods, traceability of corrections. So fortunately, because I'm with NABH for the last 15, 20 years, so we do teach a lot about how to do medical record audits. People sometimes don't take, all these assessments very seriously, but when you are caught on the wrong side, then you realize the value of keeping all these documents properly. We have a personal case in our own hospital, where despite doing the best care, things didn't go well. So records we've seen, they are backward looking kind of a thing. Now coming to documents, though this division has blurred now. Documents are information used to support an effective and efficient organizational operation. It consists of any information used to run the hospital. They are part of the PDCA, but they are part of the P, D, and C. At all areas, documents are made. And documents need to be revised. That is the difference, that documents can be revised, whereas records should never be changed. But whenever we do revision, we should again have a clear-cut document control, that when were the documents reviewed, which date, who approved. This forms part of the document control policy of a hospital. And whenever there are incidents of fire and all, courts accept whatever our SOPs are there, whatever our training records are there, we should preserve those training records. These days we have geotagged photographs and all. So all these things will be really handy to show the intent of the management. So documents are forward looking, which can be revised. This we have already discussed. So these are in a way, the difference between document and a record. So record we should never ever try to change, because sometimes we think we are smart. We will add 1 or 2 lines, but we should remember that patients who are upset with you because of any reason, they may be having a copy of your records. However smart you are, sometimes the other party may be smarter than you, and that creates a problem. So now ISO 9001:2015 has replaced these terms because there was a lot of confusion. Now the term has become documented information to be maintained, but the concept stays the same. There should be a control of creation, updating, protection from loss, retention, and you should have a clear-cut policy. This makes the backbone of a hospital. How you deal with your documents, how you maintain them. Confidentiality of medical records, again. Confidentiality is an important component of rights of the patients. Very, very important thing. Patients can claim negligence against hospitals or doctors for breach of confidentiality. And there are innumerable cases. Medical information of the patient is confidential and should not be released without the consent of patient, only except in some cases. It is the right of the patient to get the documents like admission card, discharge summary, referral forms, death certificates. So only in certain cases, like during referrals when demanded by court, or policy in writing when demanded by insurance companies, compensation cases, consumer cases, income tax authorities, we have to give. Now the common problem which last 30, 40 years I have seen, and in the last 8 years as an administrator I have seen, that common grouse physicians say कि यार time नहीं है, इतना कौन लिखेगा? जितनी देर में बोलते हैं उतनी देर में लिख सकते हैं, but they will rather spend time on everything other than writing down their notes. And they will, the question is, once the case goes to court, you have to spend weeks and weeks, so much of mental agony, trauma, humiliation, and at times financial loss also. So coming to the legal principles relating to documentation in medical legal cases and documentation as such, medical records are admissible evidence as per the Indian Evidence Act. Delayed or backdated entries have very little legal values. We should try to always avoid all these things. And if you have done it, it should have a traceability with whose permission and all you have done. And don't try to cut things and replace things. It should be cut in a single line so that your intentions are clear. And they should be done concurrently, not once the file has gone to medical record department. Dr. Satish will be discussing about informed consent, so I will be leaving it. Again, most important document. Then the evidence chain matters, not just the content. And this becomes more and more important as we are going to the digital era, that they are very much interested how the evidence was created. And known production of records can be seen as withholding evidence. And then issue of tampering, fabrication, and misuse of medical records. Again, you lose the case even before you start it. As under the Clinical Establishment Act, medical records shall be maintained in physical or digital format. Hospital shall ensure confidentiality, security, integrity of the records, and medical records of IPD patients shall be maintained in consonance with whatever laws are there. MCI may change, NMC may change very soon. At one time, in 2023, even OPD records were supposed to be maintained, then it got into abeyance. Now, some of the cases where, legal litigations have proven, one case has been published in Indian Journal of Urology also, that poor records means poor defense, no records means no defense. Then there is a case, K.R. Trivedi versus Dr. Satyanarayanan. Hospital and doctors were guilty of deficiency in service as the case records were not produced before the courts to refute the allegation of a lack of timely and standard care. However hard we may say that we did our best, if you have not documented, you have not done it. Very simple. So you have to spend good amount of efforts to ensure that it is documented well. State Commission held that there were negligence as case records did not contain proper history of prior treatment, investigation, and even the consent papers were missing. Innumerable cases, there may be maybe more than 100 cases where medical records have proven good or bad. See, in this case, C. Anjani Kumar versus Madras Medical Mission, allegation of not informing possibility of vocal cord palsy was negated by written consent that showed that it was explained properly and consented. So same thing will come handy for you if you have done good communication and ultimately documented whatever you communicated. Again, in another case, Meenakshi Mission Hospital Research Center, National Commission in another case held that hospital was guilty of negligence on the ground that the name of anesthetists were not mentioned. So again, these are the 6 C's for a good medical record. Try to capture patient's words, clarity, completeness, conciseness, chronological order, confidentiality. Neat, legible, timely, accurate with professional tone. Now this case basically belongs to our own hospital. Unfortunate. We did everything perfect. Now I'm just doing a postmortem, so there is no harm in accepting anything good or bad. A preterm baby who stayed with us for 3 months did not pay a single penny. It was a free case. And the best ophthalmologist in the city had seen the case. ROP test was done. Laser was also done. But we lost this case. So wherever I discuss, I always discuss this case. Only for 2 reasons. That the medical records were delayed. They were not given to the family in time. So if you read this case, first 10 pages, Supreme Court has spent only on this. And the minute you delay giving the medical records to the patients, you have convinced the patient that you have everything to hide. Malified intentions come. And once the court decides against you, then it becomes very difficult to convince them. And second thing was legendary handwritings. And the ophthalmologist used to come in the afternoon, 3 p.m. That is the time when they were free. So he will come do the ROP checkup, write down somewhere sideways ROP done. And nurses did not write anything corroborately inside. He said, laser done, this done. But court did not agree. They said this is all afterthought. Because they were convinced right in the beginning that the hospital is trying to hide it. We paid nearly 1 CR for this. So I am always bringing this case is that first and foremost thing is access the medical records, have a very clear policy and give them the records once you verify that it is asked by the right person. You can charge a bit of money. They can ask you 10 times. You will have to give them 10 times these records. So these are all the wordings directly from the judgment that, they said that this is a gross deficiency in the service. Then there are again, Dr. Shyam Kumar versus Ramesh Bhai case. The petitioner has not produced the medical records on the grounds that he had destroyed the same. Like, this is not an excuse. This is rightly not believed. Such a denial would lead to presumption that petitioner is not prepared to tell the truth before the commission. So absence of clear documentation means liability is established. Failure to provide record that consumer driven, like in Raipur medical negligence case, court criticized withholding or inconsistent documentation as supporting negligence. There are innumerable cases, Meenakshi Mission Hospital versus Samuraj. Again, conflicting progress cards showed poor documentation. What happens whenever there are cases? Then, so many brains enter into the IPD. Everybody comes out with their own ideas. Somebody writes this, somebody writes that. And there we create a bigger problem. Never ever temper the record. That is the second message we should learn today. There are successful defenses where proper documentation exists. There are innumerable cases again. Kamlesh Yadav versus National Heart Institute, Genome Fertility Center, Panchkula criminal negligence. The complaints were dismissed due to lack of prima facie evidence and medical record failing to show culpable gross negligence. Now, again, one thing which I wanted to stress was tampering, fabrication, and misuse of medical records. There are maybe 20 sections under Bharatiya Nyaya Samhita where, whenever the medical records are destroyed or we take a cognizance that, we are sorry, the records are missing, we have lost the case even before we started. So all these are cases against us. This form 420 is again cheating, 318 BNS knowledge. It is involved where fake medical records are used to dishonestly obtain bail, insurance benefits, employee advantages, or other wrongful gains. One more caution is certificates, false certificates or something we write down to our friends also. They come and request, "Bacha school nahi gaya, likh dijiyega." All there is a good power of saying no also. If you start telling people that I will not give it, they will stop coming to you. There are again a lot of cases. These are the cases where people got out of the negligence parts, but they, because of the alterations and all, they got again entangled back to square. So whenever there is a case of negligence, please don't do any tampering of your records. And in the era of AI, there are a lot of quasi-identifiers. What identifiable patient demographic means, like we may be removing the names and we think, we have kind of anonymized the data. But then we have newborns and sometimes extreme ages, PIN codes, then rare diseases, gender, procedure date, and ultimately it may come down to us that we are responsible for this data leak also. So we should remember that privacy is all about persons and confidentiality is all about information. And these are the 4 things when we go digitally. 4 types of information is there. Personally identified information, sensitive personal information, which includes race, opinions, criminal convictions, then protected health information, medical conditions and treatments, and online and location identifiers. Once we start collecting digital data, we have to be clear about all these things, and these all come under personal data. And DPDP Act is going to be enforced this year and some next year, so we have to be well read about what DPDP Act tells us. I think this should be good enough, and I would like to answer any questions in case anybody wants to ask.
Thank you, Dr. Singla, for excellent talk.
Thank you.
One question is always raised by everybody after this documentation talk, that how long we have to keep the records.
Yeah.
Are there any specific guidelines regarding that?
See, as far as National Medical Council is still maintaining MCI, Professional Medical Ethics Code till now. They had new medical ethics code, but then because of whatever reason, it was kept in abeyance. So we are till date, we are following MCI 2002 guidelines, which shows clearly IPD records for 3 years. And MLC, of course, we have to keep it. I think I did show somewhere. Let me just go back to those slides. It is written, yeah, see, this is the thing. Every physician shall maintain the that's what
period of 3 years. Yes.
3 years. So rest everything else is whatever people say. But this is clearly written in our Medical Council of India guidelines. Every physician shall maintain the medical records pertaining to indoor patients for a period of 3 years. The new guidelines from NMC had said OPD records also to be maintained, and then it had raised the bar that all medical institutions will go digitally within next 1 year or so. but as on date, this is what is expected. And another thing is, most important thing which I forgot, the time limit is when the patient approaches you, 72 hours, you have to give him back the records. Don't make it 73 hours also, please. That is the most important carry-home message. Once the patient you have clarified, have a clear-cut, robust SOP, how to give these medical records. There is no dilly-dallying, because normally administrators will think कि थोड़ा delay कर देते हैं, 2 दिन के बाद देख लेंगे, वो लेटर कहीं छोड़ के चले जाएंगे, रिसीविंग करवा लेंगे और अब आपकी आफत शुरू हो गई. So remember, everybody in your organization should be sensitized that if any patient wants to seek their records, or any authorized attendant or legal authorities, so same should be duly acknowledged and document should be issued. Like, we email them immediately if we feel that, we are dealing with the right person. But you have to again understand, you can't give these documents to any Tom, Dick and Harry.
So
Yes,
Dr.
sir.
Deepika Singhal,
Clarify the question. I answer.
Dr. Deepika Singhal want to ask, can electronic case records be edited post patient discharge?
No. Why should we think of that?
Yes, yes, exactly. That amount to tampering again.
100%. But
Then
why
Dr.
should we
Shishir
think-
Srivastava wants to know, is it our responsibility to immediately provide indoor papers whenever the patient? Yes, you have already answered this. Within 72 hours, we have to answer it. So
Yes.
now I request Dr. Satish
Sir,
Sharma.
one thing I want to add here,
Yes, sir.
that NMC is silent on OPD record. It has mentioned only the IPD record for 3 years. So better in our case, when a patient file litigation in the court of law, he has 2 papers with him, either the discharge card or the OPD slip. Okay, so you have to be very clear about it. So these days, doctor have started keeping their OPD record also. Either they keep one carbon paper on the original one, or they have EHR, whatever it is. So try to keep OPD record for 3 years, although the NMC is silent about it. Yeah.
Yes. I think
Thank
this
you,
year
Dr.
NLC
Deepak
will come
Singhal,
out
for
with the
such a
revised
wonderful
guidelines.
talk.
Yeah.
Now I request Dr. Satish Sharma to talk about the consent.
Thank you. Thank you
common
very much.
mistakes
Thank you, sir. Thank you very much.
we do in the consent taking, because consent, as Dr. Deepak Singhal has elaborated so much, that consent is a very important document. So over to Dr. Satish Sharma, sir. Sir is a medical chairperson of a medical legal chapter, and all credits goes to him for organizing this webinar. Dr. Satish Sharma, sir, please.
Yes, sir.
Make us wise now.
Is visible? They are visible?
No, sir.
मेरे को तो दिख रही है.
आप दिख रहे हैं सर हमारे
दोबारा
को.
करो सर, बंद करके दोबारा कर दो.
जब डॉक्टर स्पीच होते हैं तो हमको कुछ नहीं और दिखता सिवाय
नहीं,
डॉक्टर.
एक मिनट सर, मैं मिनिमाइज करता हूँ.
डॉक्टर दिनेश शक्ल दिखा दो यार, ऐसे नहीं.
वो प्रैक्टिस में बैठ गया लगता है डॉक्टर दिनेश.
अच्छा, ठीक.
पेशेंट वेट कर रहे होंगे भाई बहुत सारे.
अब सर, अब दिख रही हैं?
नहीं सर.
अब तो दिखनी चाहिए डॉक्टर साहब. ये देखो, दिख रही है सर? हेलो.
तो आपने ग्रीन बटन शेयर करके किया क्या?
पहले शेयर किया मैंने, ग्रीन किया है.
नहीं है, शेयर करके जो पीपीटी ओपन है उसको आप क्लिक कीजिए डबल.
मेरे देखो, मैं अब दोबारा करता हूँ.
दोबारा कीजिए, वो बंद कीजिए. पीपीटी ओपन है आपका डेस्कटॉप पे?
ओपन है.
हाँ, तो अभी ग्रीन शेयर, ग्रीन बटन प्रेस
शेयर मैंने ब्लू वाला
आ
किया.
गया, शुरू हो गया,
अब
शुरू
आ
हो
गया
गया.
सर, अब आ गया.
आ रहा है, आ रहा है, आ रहा है.
स्लाइड आ रही है मेरी?
हाँ जी, बहुत
Fine, अरे
खूबसूरत सी
आपका main-
सीनरी आ रही है अभी तो।
मंदिर वंदिर में पहुंच गए सर, कश्मीर आ गया
ये नहीं कुछ और आ रहा है वैसे तो वो आ गया ना।
नहीं नहीं आप
आपकी स्क्रीन आ गई सर।
ठीक है, पीपीटी ओपन नहीं
अब आ गई
आ गई
सर,
सर,
अब
आ
आ
गई
गई,
आ गई आ गई
अब आ
फुल
गई।
फुल स्क्रीन।
इट्स ऑल राइट।
हाँ बिल्कुल सर, परफेक्ट।
Sir, it is said that prevention is better than cure. Okay, so they are, uh, as Dr. One of the part, Dr. Singla has told, but we have been making mistakes, even consent. So we have to learn from our mistakes. And I brought some court cases for that in the proper consent taking. So definition I'm not going to detail that it is a voluntary and continuing permission of the patient to receive a particular treatment and based on adequate knowledge of the purpose, the nature, likely effects and risk of that treatment if it is not carried out and what is the success rate or any alternative treatment is available or not. So as per the Indian contract section 13, two or more persons are said to consent when they agree upon the same thing in the same sense. And Indian contract section 10, consent should be free consent should be there. So every individual has a right, his personal autonomy of choosing what is good for him, what is the best treatment, what are being carried method, modality of the treatment. He can refuse treatment in the beginning or even in between the treatment. The patient can refuse. So every human being adult here and consent uses the principle of voluntary non-fit injuria. It means patient is willing. It means you give consent, then it is no injury is done, sir, about it. So they are component of in the court of law, they are informed written consent is the valid consent and about the component that it should be comprehensible in non-medical terms and preferably in local language and preferably in patient handwriting. It should not be on the dotted line, pre-printed consent, written or taken by your front office staff or your nurse. It will be explained by the doctor about what is the diagnosis right now and what we are going to do about the nature of the treatment and what are the percentage of the risk involved and what are the chances of the success and prognosis if procedure is not done by you and what is the alternative treatment. And these days we should also include the financing involved in this and roughly to tell about the hospital. Say it is difficult to say about the patient asks, sir कितने दिन लग जाएंगे treatment में, हमें कितने पैसे लग जाएंगे. So you have to just finances, There are two very important landmark judgment in the consent. Samira Kohli versus Prabha Manchanda. Samira Kohli, she was an unmarried 38-year-old female and she was having menorrhagia and seen by a doctor and she was advised that diagnostic laparoscopy to find out what is the cause of menorrhagia. During this laparoscopy, it found that there were extensive, endometriosis, and she was under anesthesia, and doctor performed the hysterectomy, and salpingophractomy was also done, and the consent was taken from her mother. Later on, she went to court. Sir, I am, and she was engaged. She said that I am engaged, I am unmarried, and now they have removed my all these uterus without my consent. So the court gives judgment unless until it is life-threatening situation. Mute yourself, Sushil.
सुशील म्यूट कर लो। सुशील
So
सुशील
the Supreme Court held that consent for a diagnostic procedure does not hold for the separate medical therapeutic surgery, and valid
डॉक्टर
consent
दिनेश
must
फोन
be.
करो उसको, सुशील को।
Sushil,
सुशील
Sushil, switch off, mute yourself. IP Delhi office, yes, thank you. So Supreme Court said that the consent taken for a diagnostic purposes, it cannot be used for a therapeutic purposes or to extended surgery unless until it is a life-threatening emergency and saving the life. So this was in this court, principal obtained consent that the doctor has to seek and score the consent of the patient before commencing a treatment, and the consent should be real and valid, which we have discussed earlier, or the component, and the adequate information should be given to the patient about the balanced judgment as to whether he should submit himself to a particular treatment or not. There is one term is therapeutic privilege. When a doctor think that if you are going to tell each and everything patient and the not success rate is complication and side effect, so patient may not get psychologically upset and may not go into depression. So at that time, the attendants, they are present, the relative are present, you can discuss with them, not with that is the only advantage to the doctor, therapeutic privilege. And there can be a common consent sometime for diagnostic operative procedure where they are contemplated or before they are explained that whatever is going to do, if we find like that situation, so we may have to resort to the surgery. And the nature and extent should be of the extent which is accepted as a normal and proper by a body of medical men skilled and experienced in that a particular field. So this is a case as a permanent Katara versus Union of India that no consent is required for life-saving emergency treatment with medical treatment preceding legal consideration. So any emergency, so a roadside accident or any fracture, whatever it is, even if you are a pediatrician, then you have to give some first aid treatment and then you refer. Then the other case is refusal or dissent in life-saving emergency must be documented. Here, this was a case of acute appendicitis. This was in a government hospital. And this was a case of Dr. T.T. Thomas versus Srimati Aliza in Kerala case 1987. The doctor was waiting for the consent. But by that time, appendix ruptured and emergency was done, but the patient expired. So here see, I am taking different cases that sometime in emergency, you don't wait, and if it is life threatening or saving the life. Then proxy consent. The consent was taken from the son-in-law, not the patient. This is Sri Chitra Tribunal Institute, National Commission 2015. No negligence found on the death of the itself, as the complication was a known risk. However, taking consent from the son-in-law was deficiency in services, and the doctor's fees refunded and 1 lakh compensation awarded. Similarly, consent for chemotherapy not obtained from the patient himself. This again a Sheila Srivastava. She was suffering from breast cancer, and this was from Rajiv Gandhi Delhi Hospital, decided in 2018 May. And the patient had many complications of chemotherapy, and she said that I was not told at all that you will be given chemotherapy in the side effect. This consent was taken only from my son. So again, this was compensation awarded. Then deficiency in the other case, here Ram Gopal Varshney versus Laser Site India Private Limited and 2009 National Commission, an old man underwent cataract surgery and lost the vision. Again, the consent was signed by his grandson, though the doctor was acquitted in all other charges of negligence because the complications or whatever that, but he was liable for negligence because the consent was not taken from the patient, but he was taken from the grandson. Then failure to consent was a disciplinary action. This is all Karnataka. In this just yes, failure to obtain informed consent can lead to disciplinary action. Karnataka High Court on 2019, Dr. Ramachandran versus Medical Council of India. Doctor must obtain proper informed consent directly from a competent adult patient before any procedure. So no one can consent on behalf of a competent adult. Disciplinary action was awarded to the surgeon for not taking a proper informed consent for the entire procedure because kidney and pancreas transplant surgery was done. So this was, although they were, and because the consent was not taken. What is happened? Yeah, not explaining nature of the risk. Deficiency in the services. Although you have taken the consent, as Dr. Singla has also told in one of the case, there is nothing on record to show the exact nature of the risk explained to the in the consent is and perfunctory in the nature. The Sushma and others in the and Dr. Medicolegal cases in National Commission and 2010. So that there is no record to show that opposite party had explained the risk involved in the course of the treatment, and also no proper consent had been obtained. So deficiency in the service was held in this case. Changing surgery from laparoscopy to open without consent. This is again a negligence. C.K. Pandanian versus this SR Trust, National Commission 13. A patient consent was taken for laparoscopy gallbladder stone, but open surgery was performed instead, which was contraindicated due to the patient. He was diabetic and he had a heart problem also. The patient subsequently died. Although the complications they are known, the National Commission found the doctor negligent for not adequately explaining the reason for the change in the procedure and for conducting a contraindicated surgery without a consent. So the appeal was allowed. So in this case, the doctor was held liable for this. Handwritten material has more evidentiary value evident in the court of law over the typewritten material. So this in Dr. Sathe and Pillai cases, and in Kerala High Court 2010, the court made observation that in law, handwritten material has more evidence value over typewritten material, and physician should explain the risk involved in doing a procedure and also about the alternate method of the treatment available. The decision taken by the patient or by the relatives on behalf of the patient must be written and duly signed by the concerned party with witness. I have to hear that the witness should be not from the hospital staff or your attendant, they should be neutral witness. The staff of the hospital or any other employee should not affix their signature. And the root cause of here this communication was that this is proper consent was not taken. Then implied consent via diagnostic purpose cannot be extended to curative purpose. Again, this is a similar case as Samira Kohli, the diagnostic commission, and the Supreme Court disagreed with the National Commission that implied consent for removal of the whole mass. This was a thoracoscopy was done, and patient was explained that we will take a biopsy. But ultimately they found a mass and they removed the mass, and they even didn't call the neurosurgeon. So they took consent only for the biopsy, not for the removal of the mass. So here this was deficiency in the services. Attendant not giving consent despite repeated explanation about high surgical risk, there is no negligence. So this is called a contributory negligence, and you should also mention in the record with duly witnessed by it. So this will be a defense in the court of law. So in this case also no specific consent for open brain surgery was given by the relative despite repeated explanation. So this was maintained, and this was H.S. Tuli versus PGI Chandigarh case 2008, and NCRD held that surgery could not be performed without valid informed consent, especially in high risk neurological cases. They said the doctor has delayed the surgery, but here they have not given the consent. Then operating beyond consent amount to negligence. Ram Bihari Lal versus Dr. J.N. Srivastava, Madhya Pradesh High Court 1984. Surgery performed outside the scope of the consent, appendectomy consent used to remove gallbladder. So without fresh consent was held impermissible, and the consent should be procedure specific, and extending it amount to negligence. So if you are going to do two procedure, so in the advance you can tell the patient. So it should be procedure specific consent. Implied or oral consent accepted in limited circumstances. Although we have been saying that it will be real written valid consent, but sometime in some case to case it depend upon that. This was again a case Valuable versus Superintendent of Government General Hospital, Madras High Court, 1992, where the patient was conscious, aware, cooperative, and relative were present. Implied consent, oral consent inferred from the conduct was held sufficient. Absence of written consent alone was not a negligence. So this vary from court to court. So absence of a written consent form alone was not detriment, not to be proof of negligence, provided implied consent was evident and the judgment emphasized that the doctor's duty is to act in the best interest of the patient. Fresh consent required for every new procedure. This we have discussed. The Saleh is the appeal, and this was National Commission 96. The patient was operated for acute appendicitis in August 1993. A month later, in September 93, the patient was called back to the operating theatre under the premise of having his stitch removed, and the doctor performed second operation, and this was re-exploratory. It means he has left something in the abdomen. So following the second operation, the patient suffered great pain, lost to a finger, right hand, developed a hernia. He alleges that gross medical negligence that the second surgery was performed without consent. So this was like blanket consent is insufficient. Blanket means when the patients come to hospital on pre-printed paper or other thing, we take a consent that I will consent to Dr. So-and-so for any risk involved in the hospital. No, it should be procedure specific. Blanket consent has no validity in the court of law. Here the two cases. The one is an adult female diagnosed with a gallbladder sludge, underwent endoscopic papillotomy. She developed post-operative pancreatitis and expired due to acute pancreatitis with septicemia and respiratory failure. The patient underwent a risky procedure with a lot of pros and cons, and this should have been explained in detail. In this case, the consent obtained was a blanket consent, which was not acceptable. Similarly, the second case, PD Hinduja National Hospital and Medical Research Center versus Dr. Sanjay Agrawal, and this was in National Commission 2018. A female developed quadriparesis following surgery for atlanto-occipital dislocation. No deficiency in the treatment could be proved against the doctor, but here the consent was a blanket consent and not a specific consent. So consent is required for even blood transfusion. This case is, as you know, back to 2006. National Consumer Dispute Adversarial Commission held that the consent for the patient is required for transfusion of the blood. And the court observed in this case a doctor who performed a medical procedure without having first furnished the patient with the information needed to obtain an informed consent, which have infringed the patient right to control the course of the medical treatment and will be liable in battery even though the procedure was performed with a high degree of skill. So this was the court judgment. Signing the consent form does not exclude the doctor responsibility. Now this is a very important thing that we have been saying real valid consent, written consent, but sometimes you have taken real valid consent, but still there is negligence. It means Commission highlighted the principle signing the consent form does not exclude the doctor responsibility if he is negligent in carrying his duties. So during the operation, the doctor discovered a disease ovary and removed it. The patient husband had consented to the removal of the disease ovary if found necessary. So here, the patient, although the patient consent was not taken, and this does signing the consent form, it means does not exclude the doctor. If there is no written consent, the fact whether such consent was there is a matter of interference from the evidence. This was a Mahabhata Bhatt versus Dr. K. Krishna, 2000 in Kerala State Commission. Court observed that if there is no written consent, the fact whether such consent was there is a matter of interference from the evidence. Inference from the evidence. The Commission held that lack of written consent does not automatically mean absence of the consent, but the burden shifts to the doctor to prove through record, witness testimony, and circumstances that the valid consent was actually obtained. So key learning from today decided case, this court law, do not omit to take consent even for the minor procedure like using pleural tap, even blood transfusion or any biopsy or lumbar puncture. Disclose any risk of death or serious harm. Take consent in patient own language. Always take detailed informed consent. Consent must be signed by the patient unless the patient is a minor, unconscious, or mentally unstable. Consent must be duly dated, timed, signed, and witnessed. Make disclosure yourself only. Denial consent or negative consent or consent for the delay, it must be mentioned and into the record. Disclosure intent to perform incidental procedure to principal one should also disclose. DNR should be in Indo, it should be recorded under the CCTV camera of the hospital. Thank you very much.
Thank you, sir. Thank you so much.
Thank you, Dr.
Dr.
Sharma,
Yes.
for the excellent talks. And now there are few questions which delegates wants to know. And one practical question as regarding changing the procedure, as the example you have given from laparoscopy to open. So in that situation, we have to take the consent from the relatives only because patient is under anesthesia. So how to proceed in this thing?
Sir, if this is a life-threatening emergency, you think earlier what was, it will vary from case to case. Earlier you have seen that in that case the patient was diabetic. He has earlier heart disease. He was not fit for the open surgery, and he was agreed upon consent given for the laparoscopic surgery. So once you have taken for laparoscopy and condition of the patient was diabetic and is a heart disease, so in that case it was your negligence. If patient was having a healthy patient, and why the doctor had to resort or to change from the laparoscopic to the general surgery. In that, if it is like something cut or bleed is there or something life-saving, in that case, you can take the consent of the attendant.
And Dr. Rajiv Singh wants to know, sir, can a patient in depression or on neuropsychiatric drugs, those stable and doing their job appearing normal, give consent for the child for any procedure?
You know, sometimes we don't know, the parents come to us, we as a pediatrician, that what is the status of the children. We don't we don't ask every parents, you are suffering from depression or you are suffering from any disease or from mother also. If apparently living normal, so we take consent. If child is, if the father is in remission or is fit for to, at that time you can give consent.
And there are very rare cases when both the parents are in depression or on drugs.
Then
So
your legal guardian has to be taken.
if father is under drug, mother can
And this will depend upon case to case. What case you are doing, you are taking for POXO or you are taking for surgery or child in. So this will depend from case to case.
But we should avoid taking consent from any person who is on
if it is known to you, if you already know,
because he can refuse any time that he was not fixed.
Yeah.
And he also want to know, can patient make video of PICU, NICU ward, which is very common, if not under what section of IPC or IT Act they can be booked? What defense is available to medicos for the same? Whether he wants to know, Dr. Deepak Singla, you can also answer if you are here. Can a patient make a video of PICU or NICU?
No, the patient cannot make a video of it. Okay, even in NICU and PICU, you cannot add a CCTV for that purpose. And waiting hall in your chamber in the hospital, you can have CCTV. And in that case, you can write you under CCTV surveillance also. But in certain cases of consent, like I told you, organ donation, another thing, the consent has to be taken under CCTV. So that case, a certain legal application. And for CCTV cameras fitting into your OPD or some areas, sometimes they can be helpful to you. Sometimes the patient is certain making violence or coming in a mob or something, doing manhandling, misbehavior. So they are caught in the, or depending upon the doctor profession, whether you are a pediatrician or gynecologist or surgeon. Okay. So depending upon, you cannot put CCTV in your examination room as well.
Okay, thank you, sir. And is Dr. Deepak Singla is available? Otherwise, Dr. Sharma, you can answer. Dr. Rajiv also want to know, can a corporate hospital revert or edit the past record technically? Can a
How
corporate
past? Once you have given to the patient, okay. And I will like to add here, never give original to any except the court. Even the police is asking that you have to give photostat. Before giving, always number the file. Numbering should be there.
Yes.
Each page you should sign it and take in writing that we have taken from the doctor from the complete file this number to this number. Give the photocopy. Okay. And in the hospital, corporate hospital, then you cannot temper or you cannot, but immediately or next day also, if you want to change that, then you can just, as Dr. Deepak told, just scratch it with one line, and then underneath with there is space, you can write the change. It should not be overwriting, not doubling, not corrected, not on the side, not like that.
Means
Not
what you
different.
have changed is also should be visible.
Yeah.
What you have changed from what to what.
Sometimes, you see the file and change it, speak itself that your changes, different handwriting, different ink, different pen, and different on the one side. So it will obviously show that something tampering has been done.
Dr. Subodh Kumar Garg raised the hand. Sir, you type your question if possible. Sir, even I don't know what to do in situation of raising hand.
No, it's not visible.
Dr. Dinesh Goyal?
Sir, yes, sir. So he can just write in the chat box.
Yeah, you can, Dr. Sir, you can write in chat box or question answer.
Yes, please.
Okay, Dr. Satish, very excellent talk and so much of doubts you have clearing the web, which is called. So excellent presentation, sir. And Dr.
Thank you,
Deepak
sir.
Goyal, sir.
Thank you very much.
Both of you. And now
On the
over
behalf
to
of the
Dr. Dinesh
IIP
Goyal.
Delhi, I put my vote of thanks, sir. And I'm very, very thankful to Dr. Satish Sharma, sir, Dr. Deepak Singla, and Dr. Hemant, and everyone, and especially Dr. Deepak Gautam, sir, for moderating wonderful session. And with this, thank you so much, sir. Thank you so much, sir.
Thank you.
Thank you, sir. Thank you, everyone.
Thank you all who attended this webinar.
Thank you, sir.
Thank you, Dr. Dinesh.
Yes.
Thank you.